All right, good evening, everyone. I'll call tonight's meeting to order for Wednesday, May 3rd, 2023. Mr. Metz, will you call the roll?
Gary Gross.
Here.
Jim Hall.
Here.
Todd Moore.
Here.
Christopher Ambergy.
Present.
Jerry Heidenreich.
Here.
David Cash.
Here.
Stephen Wanamaker.
Here.
You have quorum.
Thank you. Please rise and join us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next on our agenda is our meetings from April the 5th. Hopefully everyone's had a chance to review the minutes. Are there any changes before I call for a motion? Any questions or changes to the minutes before I call for a motion? All right, seeing none, do I have a motion to accept?
So moved. I'll second.
Stephen Wanamaker.
Yes.
David Cash.
Yes.
Jerry Heidenreich.
Yes.
Christopher Ambergy.
Yes.
Todd Moore.
Yes.
Jim Hall.
Yes.
Gary Gross.
I must abstain, I wasn't here.
Great. That brings us to our first case this evening, case number 523, a request by applicant Toby Baker for approval of a use variance for the property located at 2019 Oxford State Road and 3228 Omaha Street. Before we get started, we'll need to swear in Mr. Metz.
Do you solemnly swear that the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I need to go on record.
Let the record reflect that Mr. Hall is going to recuse himself from this case.
I will recuse myself on Mr. Baker's 2 cases. I'm afraid I can't provide an unbiased vote.
Thank you, Mr. Hall. Okay, so tonight before us, we have 2 variance requests. Request by applicant Toby Baker for approval of a use variance for the property located at 29 Oxford State Road and 3228 Omaha Street. The property is zoned R4 attached residential district. The 2 variances were requested. The first is to allow shipping containers for commercial storage where the Middletown Development Code states the use of portable shipping containers in semi-tractor trailers used for storage with or without wheels should not be used as permanent accessory structures in any zoning district. The second variance is to allow the continuation of illegal non-conforming use of retail sales and services. Below, as you can see, is a picture of Mr. Baker's property. The property is zoned R4 attached residential district. The purpose of the R4 attached residential district is to provide for moderate to high density residential development generally located in the core area of the city, and that reflects the historic urban development pattern in and around the downtown Middletown. Here's the property. This is, I believe, 3228 Omaha, and I believe this is 219 Oxford State Road. The applicant would like to receive a use variance to allow the current retail business to be permitted as the previous legal non-conforming status was reverted due to the inactivity of a retail-oriented business on the property, and the applicant would like to be permitted to utilize the shipping containers for commercial storage on the property. I just kind of wanted to recap that, and I will recap that at the end. In addition to that, the applicant would like to build a new building as proposed by Exhibit E that was provided in the staff packet and provided by the applicant here in this circle. That's not on tonight's discussion, though. So the Middletown Development Code, Table 1204-3, principally permitted uses, does not permit retail and service or commercial uses within the R4 district. The Middletown Development Code, Chapter 1224-05, nonconforming uses, G, termination of nonconforming uses states, subsection, termination of use through discontinuance. When any non-conforming use is discontinued or abandoned for more than 12 consecutive months, any new use shall conform to the regulation of the district in which it is located, this being the R4 attached residential district. And the non-conforming use may not thereafter be resumed. The intent to continue a non-conforming use shall not be evidence of its continuance. Additionally, as you're aware in the staff packet by the submission of the applicant, there was a fire that burnt down either a portion of the building or all of one building that was attached to the other one. So subsection termination of use by damage or destruction. Subsection B, if a non-conforming non-residential use in a residential district is damaged, but not to an extent greater than 50% of the principal structure market value according to the applicable county auditor, such structure and use may be reestablished on the same lot to the same size and intensity of use as was previously existing immediately prior to the damage or destruction. Such reestablishment of the use shall require the issuance of a certificate of zoning compliance. There was not a certificate of zoning compliance issued at that point in time. C, if a non-conforming non-residential use in a residential district is damaged beyond 50% of the principal structure's market value, according to the applicable county auditor, such structure and use may only be reestablished with approval of the BZA after consideration of surrounding uses and the impact of the non-conforming use. Such review and determination shall be made at a public hearing held in the same manner as a variance. See section 1226.10, including notice, but the variance review criteria of 1226.10C shall not apply. There was not a hearing after the damage or destruction that the property received. This moves us on to our second variance request to the Middletown Development Code, Chapter 120601, Accessory Uses and Structures. C1 states, except as provided in code, the use of inflatable garages, portable garages, and temporary structures as defined in Section 120602, temporary carports, portable containers, shipping containers, and semi-tractor trailers used for storage with or without wheels shall not be used as permanent accessory structures in any zoning district. This was a photo provided by our code enforcement at the time of the zoning violation was issued. Here's a picture of the property in 2009. Here's a picture of the property in 2013. In August of 2016, June of 2019, October of 2021, and then last September. Per the Middletown Development Code, the requirement for legal notice for variance requests, meeting notice letters for the proposed variance were sent to all property owners contiguous and directly across the street or of the public right-of-way, and no comments were received. Chapter 1226.10, variances. Per the Middletown Development Code, the purpose of variance is to provide limited relief from the requirements of the code in those cases where strict application of a particular requirement will create a practical difficulty or unnecessary hardship prohibiting the use of land in a manner otherwise allowed under this code. It is not intended that a variance be granted merely to remove inconveniences or financial burdens that the requirements of this code may impose of property owners in general. Variances are intended to address extraordinary, exceptional, or unique situations that were not caused by the applicant's act or omission. In order to grant a use variance, the BZA shall determine that strict compliance with the terms of this code will result in unnecessary hardship to the applicant. The applicant must demonstrate such hardship by clear and convincing evidence that all the following criteria be satisfied or are satisfied. The property cannot be put to any other economically viable use under any of the permitted uses in the zoning district in which the property is located. B, the variance requested stems from a condition which is unique to the property at issue and not ordinarily found in the same zone or district. The variance requested cannot otherwise be resolved by a zoning map amendment, or a zoning map amendment is not the most beneficial approach. The essential character of the neighborhood will not be substantially altered as a result of the variance. There is an existing structure that cannot be reasonably used for a permitted use or conditionally permitted use in the applicable zoning district. The proposed use is listed in Table 1204-3. The hardship condition is not created by actions of the applicant. The granting of the variance will not adversely affect the rights of adjacent property owners or residents. The granting of the variance will not adversely affect the public health, safety, or general welfare. Before I read the appeals, I just want to go back and recap what the applicant is asking. So the applicant would like to receive a use variance to allow the current retail business to be permitted as the previous legal nonconforming status was reverted due to inactivity. And the applicant would like to be permitted to utilize the shipping containers for commercial storage on the property. Any person or entity claiming to be injured or aggrieved by any final action of the Board of Zoning Appeals has the right to appeal the decision to the Court of Common Pleas as provided in the Ohio Revised Code Chapters 2505 and 2506. That ends my staff report, and the applicant is here.
Any questions for Mr. Metz before we open the public hearing?
I do. Mr. Metz, in an attachment by Mr. Baker to his appeal, well, maybe I'm premature. That's on the appeal.
Open the public hearing first, yeah.
Okay.
I got a question. Can you put the photograph of the property up there?
Yes, which one?
The one that shows the buildings in the picture. Yeah, there's a back building, and that back building is part of the back lot there. I don't know which one, at 3228. Is that property on there?
I believe that's 3228 Omaha, but I would like to defer to the applicant.
I do have a general question. Does the presence of the temporary shipping containers on the property, does that negate the ability of Mr. Baker to obtain a permit to construct a conforming building?
No, the use of the shipping containers does not prohibit him from applying for a certificate of zoning compliance for any new commercial storage building.
Okay, thank you.
But that is his belief. Is that what you read?
What's that?
I read that was his belief.
Well, I'm just asking a general question because I think that's on the appeal.
Yeah, that's what
From
I'm
the
saying.
denial of the,
In his application.
I'm just, from a general standpoint, this particular R4 zoning, with that particular, it looks like there's 2 storage containers on there. Would the presence of those 2 storage containers negate the ability to construct a conforming building structure on that property?
No.
Okay.
At this time, I'll go ahead and open the public hearing. Anyone wishing to speak in favor of the variance, please come forward. Mr. Cash will swear you in.
Good evening, everyone.
Hold on, I'll swear both of you in at
Okay.
the same time. Do you solemnly swear that the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Would you prefer to swear or affirm?
Affirm, I do,
Okay,
yes.
Thank you.
My name is Hallie Bareilles. I'm an attorney with the law firm of Flagel and Papakirk, and my colleague, Jim Papakirk, and I have been representing the Baker family. And I just wanted to address a couple of things that were discussed through the review of the staff analysis. The first one, and I don't think this came up in the staff review, is that his intention is to remove the shipping containers once the building is constructed. So they're needed for temporary storage until he's able to get that building constructed. And I believe it was our understanding that he couldn't get the permit to do that while this notice of violation was pending. If that's incorrect, we were not aware of it. Are there any specific questions?
Yeah, that's the crux of this matter, it seems to me. If the intention is to construct a conforming building on that property in lieu of these structures, I'm looking at Mr. Baker's attachment, and I have to rely upon the attachment to his appeal. It says here specifically, I had it here. The property owner, Mr. Baker, has been unable to obtain a building permit for the construction of the replacement building due to the presence of the shipping containers, which is the subject of the notice of violation dated March 16, 2023. If that's not the case, as Mr. Metz just indicated, it is not, then I'm wondering why hasn't a permit been requested and a building been constructed?
Well, that isn't the only subject of the use variance here. The other one is to continue operating the business, but perhaps.
While the shipping containers are there.
Right.
Sure. I understand that.
Perhaps you can speak to that, because I don't have any information relating to that. I mean.
If you're talking about, why didn't I apply for a permit? Because she put.
I can only look at what you've said, Mr. Baker. Are you Mr. Baker?
Yeah, I am.
You haven't identified yourself yet.
That's what they said, told me up there at zoning.
Okay.
So they said I couldn't, they told me to hold off on that, because this is when they informed me that they had pulled the zoning from commercial back to residential. And it's the first I've heard of it, when I got the notice about the shipping containers. So when I asked about it, I said, my plans are to put a new building here. She said, well, you want to hold up on that until we go through the.
Who was that you were talking with, ma'am?
City's name?
Sir?
I think it was Ms. Wells.
I believe. I'm not 100% on what it was.
Okay.
But anyhow, she told me,
It,
I want to say Deborah, maybe.
It would seem to me that this is a simple resolution. Build a structure on that property for the purpose for which those shipping containers are currently being used.
But she told me I wasn't allowed at the
Okay,
time.
all right.
This was straight from zoning, so I had to abide by what they said, right?
So,
May I interject one question, David?
Sure.
Your time. Did she say that you weren't permitted, or did she just say hold off until? Because
She
that's
said
what you
both.
just said.
You're not permitted, you need to hold up on that thought. I said, I can get the building put up there ASAP.
I'm just trying to
right
figure
now.
out if it was just a misunderstanding,
Right, well, it
or
may-
if you were
Could have been,
prohibited.
but I heard what I heard, and she said you gotta hold
I
up
understand.
until you go to
I just wanted to clarify.
apply for a variance and all that stuff, yeah.
Okay.
Mr. Metz, may I ask a question? Is it the fact, so having these shipping containers has caused an open violation? So was it said, would that stop a permit from being granted on a property having an open violation?
Not for having open violation. I was there when I spoke to Mr. Baker with Ms. Wells, and what was determined is that the legal nonconforming status of this business was reverted back to R4, which is residential. He could still build a barn on his property if he wanted. That's not stopping him for using 3228 as residential and building a barn. But for a commercial point, he would need to get a use variance to return the legal nonconforming status back to commercial. So from residential back to commercial. But that wouldn't stop him from building a structure on his site because he has an open violation.
Thank you.
Not to the best of my knowledge.
So the issue is strictly the storage containers.
The issue is two-part. So at one point in time, the use of the commercial side of the property became inactive for a period of time greater than 1 year, which reverts the commercial use back to the current zoning designation, which was R4. So R4 would not permit retail and service commercial uses, which whether it's a tire shop or auto sales or it's small appliances, those all fit within retail. So it's to get a use variance to permit that, and then it's also a use variance to allow the shipping containers to be on the property for commercial storage.
I want to go to the letter as well, since we're referencing this letter. This is the letter from the attorneys. This is 2019. I believe this is a letter that Mr. Cash, Mr. Ambergy both are referring to. I'm just trying to construct a timeline for a moment, okay? So the building we know, it burnt down in 2012. That was 11 years ago. You indicate that you have a desire to create the business there. And about 2014, 2015, you became certified, it reads in the record, so that you wanted to create a business working on appliances, create a business called Affordable Appliances. That's 8 years ago. And then we come to the storage containers itself, which have been in the photos for well over a year. So we have a timeline that exists here. At no time during that 11-year period, have you, at any time during that 11-year period, did you apply for any kind of building to be built on that site? Did you reach out to the city?
There's a reason for that. When I got knocked out with the arson, honestly, it just knocked my legs out. I mean, no insurance.
Okay.
I was ordered restitution of $250,000. I think I've got a total of $300. Guys, just a real piece of work, and that's what I received, and nothing else. And once it exceeds 5 years, it goes to civil, and you get nothing. So
Okay,
it's a long time to recoup that kind of money.
It does, but when we look at the shipping containers, because there's two issues that we have to differentiate between. One is the more than half the building burned down. It's complete loss on your part, so we have to deal with that issue. But I want to focus just for a moment on what you're asking, okay? And you're asking to use these shipping containers as a permanent use. Is that correct? Now, your attorney said no, you want to build a building there. So when would you plan, what would be a feasible timeline for you if you were to get a variance to be able to do this?
I think it's 6 months,
Yeah,
right?
I need at least 6 months.
Okay, so I would like for us to look at the code, which is 120602D9. Are we able to look at the code?
Do you want me to like pull it up on the
I
internet?
would, just so we have it for reference, because I think it's important. So we're looking at 120602D9. If we could just bear with me just for a moment as we get this code up. $1206.
Yep, there it is.
Yep. I think this will be relevant not only for this particular issue, but also for the appeal. So that's why I'm asking to have this text in front of us now. I'm talking about the appeal for the next case, but.
D9, correct?
Point on
120602 D9.
D9, okay.
I think it's a little further down, yep. Now, in that section, it lays out what we consider to be temporary and what we consider to be allowable temporary uses or storage uses. And when we look at number 9, it starts to talk about the various types that are commercial in nature. So you're using it currently as a commercial use, right?
Storage, yes.
It's storage as a commercial use right now. So essentially, what you're asking for, at least in part, is you're asking for, under this section, you're asking for more than what would be, first of all, it's a use that is prohibited in all zoning districts for these particular storage units. That's one. Now, there is, from what I read in the language, there's some administrative discretion within that language that would look at these circumstances. You're using this for commercial use. It seems to me that here it says 90 days. That's what I was trying to show. The maximum would be 90 days. You're saying 6 months. But the timeline that we're looking at in terms of this overall project or the business that you're looking at, you've been looking at this or desired to have this business going back multiple years. And if we narrowly focus on this question, at least going back to 2021, if I'm correct, you've used those storage facilities as a commercial use since 2021, is that correct?
Roughly.
Okay. So I guess the point I'm trying to make is, right now, even asking to use that for 90 days, 6 months, it's a prohibited use anywhere in the code. So that's one issue that we have to consider. Does that make sense?
Yes.
So when you're saying that you need more time to do something, the question then would be, if we're talking about a use that cannot be, that's prohibited on that site, what would you propose as a remedy to solve the current problem that you have? What would you do with the appliances and the other problems while you build something on the site? What would you propose?
Would you have to shut down or move? If you had to remove the shipping containers now?
I have to close down, or I know where to put them until that time it takes to get the building up. And with it being spring, I don't know how far back the builders will be backed up. I'm sure they'll be backed up 3 or 4 months.
Okay, so you're not certain when that would be. It could take you 3 or 4 months. What I'm really trying to say is whether or not you have if you have a feasible request at this point. Is the business even feasible? So if we were to expand on this idea of allowing you to do something there to temporarily store something, one, you're asking to store something in something that's prohibited under the code. There's a prohibition on that particular storage that you are currently using, the shipping containers. I'm just trying to look at what exactly, the idea that you would be able to ask for a variance on a prohibited use, I think there's a pretty big conflict there. Again, we're trying to reference, if you're saying it's a commercial use, when we look at section 120602D9, it lays out here there's temporary uses that you could potentially store something in. But what you currently have on your site is a prohibited use. So you're asking for a variance on something that's a prohibited use. And even if you had something there that was temporary, code says 90 days, and you're not certain when your building would be constructed.
Mr. Baker wants to cooperate with the city in getting a replacement building built. I don't think we know exactly what that timing looks like, understanding that builders may be backed up. We were looking at 6 months as being a realistic amount of time for him to get that completed. And I can let him speak to whether or not he's willing to set that in stone, or, what the city would like him to do under these circumstances. He's just not sure he can get it done in 90 days.
Sure. Okay.
I got a question on the building itself that you conceptually,
Same thing was there before as a pole barn.
and it's the same size.
30 by 40 exactly, because the concrete's still there. And with the loss I've already had, it's good to save that. It's probably $10,000 I don't got to spend. And it's not damaged, so.
And see, sir, this is where I struggle. If you had that permit, we would know it was in compliance. But you say you weren't able to get that permit, the building permit. Well, okay, so Counselor, you understand this is a catch-22 from my vote. I wish he could say, well, I have a permit, or I have a diagram, I have the design for the building, it's been approved by the city, so it's just a matter of getting the materials and having it built. We don't even know if what he wants will comply with the building code.
The attachment that we submitted with the documentation is the exact same thing. As I understand, it was the exact same thing that was built before. And he was told when he approached the city, and I was not there, and my understanding is he spoke with Ms. Wells, and she said this was going to be sufficient.
And you would honor that?
Excuse me,
I'm saying you would honor that as a point of law?
Me or her?
No, I'm asking the council. In other words, there's no formal approval for it. I know you know what I'm saying.
yeah, I understand what you're saying, but I wasn't involved in that time, and I wasn't communicating.
Your point, I'm just saying this is where I'm struggling. I'd like to help him, I don't know how. Because number one, the circumstance that we're faced with here, the situation he's in now, it's not only the zone that he's in, it's not permitted. What he has done, the position that he's in, it's not permitted in any zone in the city. As I looked at all of these on tonight's agenda, it's the same for all three of them. They're not permitted in any of the zones.
I understand that, and I, of course, I saw that in the code, but I think there's some frustration here because as Mr. Baker drives down the street and drives around town, he sees shipping containers all over the place. And if they're prohibited everywhere, they're very frequent. I mean, we have a couple of addresses we can note.
Sure, I've read this.
Yeah.
I've read that. That's something that's a city problem.
Yeah.
I agree.
And, you know, I would just reiterate the request that they be permitted to stay there until he can get this building constructed, and we're looking at 6 months.
I'll let that. I'm just trying to explain my vote.
I understand.
At a loss.
The property that you have, let's look at the other property that you have at 3228 Omaha. What's the intention with that building there? Will that be a commercial operation that you have? You'll sell things from the building, or is it just maintenance?
Business, yeah.
Okay. Will it be storage attached to that building as well? Is there any
I
plans?
don't
Or
know if I'm gonna attach them or not. I probably won't attach them.
The storage you're planning to build, the building, would support both the one existing on the Oxford State Road as well as the one on Omaha Street?
No, that's a home. That's my home back there.
Oh, that's a home?
Yeah. It's just all on one deed like that. It's always been like that. Ever separate.
That was the original question I had, what building is back there?
You asked me what's back here? It's a home.
Did you want to put the pictures back up there so we can point it
I
out?
understand that, because I thought you just said you were gonna support a business back there as well.
No, business out front. It's all, the whole corner's one deeded lot.
Okay.
And for as long as I can remember, and my father can remember, who's 80 years old, it's always been a commercial piece of property. They got annexed from Lemon Township to Middletown, and we got annexed by Middletown, and you guys started trying to pull the zoning, so I had to go back and get a variance.
Okay, so you live in the larger rectangle on the top of that, your top, north or whatever direction it is, okay.
And just to be clear, that's going to stay your home. You're
Yeah.
planning on leaving that residential. Okay.
So the storage, I took a look at your site. I drove by the site today. There are a lot of appliances that are in the front of the building at this point. What do you plan to do with those
In
current?
the building. That's what the building's gonna be.
But how long have they been out there? How long have some of these
They
things been out?
rotate daily, I mean, in and out, and then they get into the containers until I get a building built.
But you do recognize that having those out on the corner of the street is a problem for the city, I would imagine. Would you agree with that?
I mean, yeah, it can be or is, but they've not came at me and said, look, we'd like for you to do this or do that. And I even asked Ms. Wells, is that her name?
I think so.
I asked her, I said, look, just tell me what you want me to do. You want me to put on that concrete for right now, put a fence around them? Tell me what you want done. And she put everything on hold until we get done with this. I mean, I'll do whatever she needs done. It don't matter. I mean, I could make whatever happen, but until I came and applied for a variance and all this stuff and got approved, she said, you're just kind of wasting your time, just hold up.
What I understand, though, is the reason that we're having this step first, looking at the storage containers, is, one, you're using a prohibited storage container for your current products or for your business. So they're asking you, I believe, that you would have to do something else there to store those units while you're building whatever else you would want to build. You just can't have them out in front of the property.
Just tell me.
Well,
That's the only thing that's gonna work, so you just tell me what you want done.
I think they have, in some ways, told you. I don't want to speak for the city, but I think that they're saying that what you're currently doing, you have to address something that would actually be in compliance with the code. So that would be a temporary storage unit. You can't have the current storage units that you have out there, which are, shipping containers. You have to figure out something
What you want me
else.
to do?
Are you referring to temporary storage that is of some other type than a shipping container?
Yes.
like a pod or something like that?
Well, we have to go by the code. I mean, certainly we have to go refer back to the code. That's why I wanted us to take a look and differentiate between what we would consider to be a temporary storage for commercial use and what's being proposed.
Would a fenced-in area be considered a temporary storage that would satisfy you? If you fenced it? Yeah.
Pod would just be a
But there's a,
substitute for, it wouldn't comply either.
right, there's a compliance issue there as
Yeah,
well.
yeah, pod wouldn't do it.
So excuse me for asking a question, but you're trying to tell me that the business of pods, you cannot use a pod to move in your properties, is that what you're telling me?
No, I'm not telling you that.
Okay, I'll just ask.
Certainly not telling you that.
Well, back to my question. Is it, amongst us here, is it a reasonable approach to give him some time and fenced in an area and put his storage in a fenced-in area further in back in the yard or something? Get it off the street and get it in a more isolated area while he's building a building? Is that unreasonable?
That I can do.
I understand you can do it, and I'm glad you're willing to. I'm just trying to understand if we're willing to.
Can he do it?
Yeah.
Can he do it?
Well, with a time constraint of 1 year to get it all completed, as far as a variance is concerned. That's how I see it.
And what are we doing to the city? I'm devil's advocate here. I want to help him, but this is something, we're going to see more and more of these, because much of what was presented to us was very well presented, by the way, is for real. These trailers, or whatever you want to call them, this is a big thing. It's coming. We have, out west, they already have entire communities, people living in these things. This is all for real.
I agree with you.
It's something that the city better be preparing for in the code and in all aspects. But,
I would just qualify this from the standpoint that he has a hardship, that he had a business there, and he has a problem getting insurance paid for the fire that he had, and that contribute to the situation he's in now.
one thing that troubles me, why has it gone this long? See, now the city's on you.
I can answer it.
Okay,
Finance.
okay,
I got burned out by a low rent piece of shit.
I understand, and I believe you. It's important to me that you know that. See, I know more about that area than you know.
No, that's fine, but I'm just saying it's a fact, it's all
I know some
documented.
fine people who lived there, went to high school with them.
Nothing
Great-
but good people down there.
Great people.
Growed up living there my whole life.
But my point is, what has changed? How are you going to finance it now? That's what I'm saying.
That has changed. So you don't stay broke forever. You
I'm
come up.
sorry?
You don't stay broke forever.
Okay.
You come up.
You have the ability.
Yes, I do, or I wouldn't say I could do it.
Build it.
I absolutely can build a building.
Have you,
Cash.
have you proven that to the city?
What do you want? You want to?
No, I don't want a thing.
Who's the city then?
I'm a volunteer here.
Okay?
I'm a volunteer citizen of the city of Middletown. I'm saying, what can you prove to the officials who have the responsibility to see that you abide by the code, by the way? That's why we're here.
I got it.
It's not against you.
I got it, but I have the cash to pay for the building. Cash. It's not a problem. Finances is no longer the problem. The problem is time constraints and dealing with this container issue that who even knew this even was a problem? I never knew nothing about it. Everybody in town has them. Even the city's got them. Are you aware of that? Anybody here aware of that? Even the city, the fine city of Middletown has them.
I'm well aware of it.
Well, what the hell? What am I in here for then? Why is it?
Code?
Why don't they drag the city in then by the code?
Well, you're asking the wrong person. I'll say it again. I'm a volunteer. I'm a citizen.
I'm asking him then. Why don't you drag him in then? Why don't you drag the city in then?
Okay.
You got him?
That's good. You're a citizen. You've done well here. Now, he has the cash, Jerry. How long has he had the cash? Why hasn't he already done it? Okay, that's my question back to you. Now, it's done with between you and me. Now let's talk about how maybe we can work it out for him.
The proposal there, as far as I'm concerned, and I'm asking you guys if that's something that you guys could live with.
I think to Jerry's point that I think what you're leaning toward is that the keyword is temporary. And we have a very finite limitation on if we were to do something like that, that it would have to be, it would have a drop dead number of days, and that is it before more action is taken. I'm assuming that's what you were getting at, Jerry, that,
Right, I mean, I believe that he's legitimately trying to get his business back in shape, and I am not going to vote against that. And I am concerned, as we've mentioned here, that it propagates further around the city and have future things as well. We have to have those considerations as well. That's why I need to feel that we're qualifying your situation such that it's unique. And I believe that it is, and that you've presented your history.
Now we're talking.
um,
Put it well, drop dead terms.
Well, before we get to deliberations, we're still in the middle of a public hearing.
Okay.
We haven't gotten to
Sorry.
that stage yet. Let's keep focused on the issue before us just for a moment. Do we have any other questions for the attorney? And
I do have one question. Could any of your product be consolidated, could it be consolidated to one container or anything like that, or smaller types of storage units?
I could do that, or I could do what he said was a pretty good idea. If you guys want it, I don't care to fence it in a spot and put them in there. I don't have a problem with that.
But it could be consolidated, because right now, you can see they're a little spread out and brings a little attention that way, so it can be consolidated. Okay, thank you.
If it were necessary to move the shipping containers behind the existing building, is that a possibility as well?
We gotta move the rail anyway, once on the concrete build.
Right, well, I meant,
Yeah, I could put 'em up.
behind the brown building.
Yeah.
I have a question. Mr. Metz, would you go back to the temporary commercial structure section preceding what you have up there now? Yeah, keep going. I saw that there somewhere.
scroll up a little bit more.
Yeah,
1206 right there also talks about in that paragraph 1, temporary uses or structures not listed in the table are prohibited unless the Development Code Administrator determines the proposed temporary use or structure is similar in scale, intensity, and use as a temporary use in the table. I'm not certain if that's where you were going, but.
no, I was going back where it describes what's acceptable as a temporary structure. No, that's not it there. Anyway, what I was trying to get to, one of the things I saw in there, oddly enough, an acceptable storage structure is a semi-trailer, which to me isn't a whole lot different than a shipping container, except it has wheels.
Say is or isn't?
Isn't, or is the same basically, except it has wheels. I mean, it's, because you can see these in the back of trucks, obviously, when they move them out. But a semi-trailer is approved for temporary use. I thought I saw that somewhere in there.
Mr. Gross, except as provided in code, the use of inflatable garages, portable garages, temporary structures as defined in section 120602, temporary carports, portable containers, shipping containers, and semi-tractor trailers used for storage with or without wheels shall not be used as pertinent
It's
accessory
permanent.
structure.
Yeah.
Yep.
I was thinking temporary. Which means, would he be in compliance if those were in a semi-trailer, since it says it's, can be used for temporary?
Temporary commercial storage is
Yeah.
maxed out at a maximum of 90 days.
Yeah, that's the one problem with it, you're right about that. Is that something we could extend? As far as the amount of time to put it in there and use it? And then as soon as the building was complete and the appliances were moved, then those go out.
Well, you have two use variances in front of you, and you can vote on either individually, both at the same time. You can even modify your approval. That would be up to you if you wanted to put a time length table on it.
Well, before we get to deliberations, I know we're eager to do that. Is there any other questions we want to ask? We're in the middle of a public hearing. Any other questions for the attorneys at this point?
No, I just want to know if they have anything they want to say finally.
Okay, well, is there anyone else wishing to speak in favor of the variance? Anyone else wishing to contribute to the current variance? Anyone else wishing to speak in favor? Okay. Is there anyone wishing to speak in opposition to the variance? Okay, seeing none, now we'll move to the deliberations. I guess we'll continue to ask a lot of hard questions here before we move forward. So I think I want to go back again to what's being asked. It's, I really wanted to focus again on the request itself, make certain that we're all clear again. Right now, we'll have to decide two issues. One is whether or not that we allow a variance, a use variance for the current property itself. And then secondly, we're looking at what to do with this question of shipping containers and what remedy that we would like to look at. One of the issues that I have in terms of process here, the chicken or the egg question, for me, in terms of which one do I put forward, it seems to me that we have to focus on the shipping containers itself before we were able to say that we want to allow some type of usage for this facility to go back and revert to a commercial facility itself. I understand that there's a reasonable question there. When you look at Oxford State Road, when you look at the property and what you're intending to do, I understand the question. I think, it's a separate question. I struggle with what I consider to be irresponsible business practices, having all these units out in front of your business. That would be something that no business could do. So you are asking, and legal counsel for the city could also, and Mr. Metz, please let me know if I'm heading in the right direction. I mean, you are asking for a variance for shipping containers that are prohibited anywhere in the code. And the rationale that you're using is just give me some more time. Give me more time. And we have a timeline on this building that goes back with good intentions, but there's been nothing so far that's taken place to demonstrate that you're going to move forward. So looking at these shipping containers itself, asking questions about what to do to give you more time, I mean, when we look at the code, if we look, let's assume for a moment that we can do this, you would have 90 days under 120602D9, unless there was some good rationale that you're in the middle of the project, and that would be something for the city and Mr. Metz to look at. But, I mean, you are asking to continue to use these containers that are clearly prohibited under the code. My own opinion about trying to find a remedy with putting fencing and things like that, that doesn't answer the question that we have before us. I certainly want to find some remedy for you, but at the same time, trying to balance the two sides. One, to be able to clean up this property, and then secondly, to look at whether or not you were able to move forward in compliance with the code.
Yep, I'm able to.
Others, please join me. I mean, if there's a question about whether or not you can build a building, asking to build a fence and everything else seems to be out. We need to see that you're moving forward in a building design. You need to be able to do that.
These people, which is the city, to give me the okay, they've had me sitting on my thumbs waiting for this. Or I could have had a building up.
Well, you could have had a building up probably from 2014 to now.
I was gonna say,
You've had-
2013, the notice of violation was filed, 2012.
You probably don't want to go there. Let's move forward.
I mean,
Well, listen, I don't mind to go there. It don't bother me a bit.
but for hard,
The point is, you're not helping
You
this
guys
guy.
can't get into my finances.
You're not
but
helping
if
this
I
guy.
may, just let's hold on a second. Let's stay with what the code and the hardship criteria requires, just for a moment. I know there's a motion here, but whether your finances are in order or not is not our question. That's not a rationale for a hardship, okay? The hardship would be whether or not, we can bring the hardship criteria up that we need to look at. That's not our question tonight. This is what we have to decide before us. This is where we have to go. So I want to bring the board's attention back to the variance. So I think what you're primarily asking is, give me some more time, let me demonstrate that I can do this, and good things are on the way. Is that correct?
Yes, Mitch.
No, I mean, we need
No,
to,
I'm serious, I've been waiting to do this, I've been waiting on the city to give me the okay to do it. They told me to wait till we come to this. I just been having to sit and wait. I haven't asked for no time, they're, told me to wait till I get a variance okay to do anything. No, I haven't been, neglecting it or none of that. I just been waiting on these guys to tell me I can do it. And I didn't know I couldn't have a shipping container. I never heard nothing of it until I got that,
Code
January
violation.
letter, code enforcement letter.
Right.
Never heard nothing about it. I was just thinking of a quick way I could use for temporary storage. And the only solution I could come up with was them containers. And that's what I did.
so this would be a question to Mr. Metz and to legal for the city. I mean, we know that these shipping containers are certainly prohibited. Is that correct?
That is correct.
And you're also asking, but if we were looking at some type of remedy, if we were to say that 120602D, looking at temporary storage for commercial usage, I mean, do we have to go down this path first and foremost? If we modified this to allow him time to determine whether this is a feasible project for him or not, whether he could finance, otherwise, just build this building, I mean, the maximum that you'd be allowable is 90 days, is that correct? And then we could also attach conditions to what would happen within that 90 days, is that correct?
Well, so if he was going the temporary storage route that's permitted within the 90-day time frame, he doesn't actually need a use variance. But what he's asking for is permission to do something that's prohibited on the property, which is store his appliances in these storage containers. So in the scope of that, his actual request to use these storage containers to store his commercial merchandise, you can place any reasonable conditions that you deem fit for that use. They could be time restrictions, it could be that he limits the storage containers to one container. I heard a board member offer that. So you could place reasonable conditions on his request.
With the current storage containers that he has there?
Correct,
Yeah.
that is his request, to
Yeah.
continue using those.
And we could narrowly look at that question only before we move forward after that 90-day period, whether we would take a look at the second part of his question. Is that correct?
Well, you've got two use variances on the table right now, so if the applicant would be willing to continue that commercial retail business use variance, theoretically, you could do it that way, but I don't necessarily see the wisdom in that. I don't see what the purpose of that would be.
So you're saying look at only at the shipping container question?
I'm saying look at both use variances that are on the table now. They are interrelated.
Sure they are.
Feedback?
We could also attach a condition to this that once the building is complete, that the shipping containers would be gone, correct?
Absolutely.
Okay.
I thought that was a piece of it.
It's your intention, if, once your building is completed, to remove the containers that you're using now?
That was spoken already.
Okay,
Kind of a given, yeah.
okay, so that's fine.
I just wanted to clarify that.
That's what is in compliance with code, which you seek, right?
Well, if we look at this whole notion of whether or not it's more likely that it's a commercial than it is residential, I think it pretty much leans towards a commercial. Would we be in agreement with that?
I'd say the highest and best use for that property would no doubt be a commercial property, in my opinion. A commercial.
Commercial.
I agree with that.
And then if we're looking at the second part with these storage containers, I mean, I would argue that in terms of conditions, I mean, all appliances, anything that's outside that, that has to be cleaned up. I would certainly think that that's reasonable, and I would think that I would only be in favor of granting what is in the code at 120602D9, which would be a temporary unit for 90 days. And if you couldn't justify something beyond that 90 days, where do we go from here?
Well, I mean, he's constrained by when he can get the building constructed. And, you know, I don't know that 90 days is enough, but, you know, what happens if you allow it for 90 days and then he has a quote that it can get constructed in 100 days or something? I mean, would he need to come back here and request a second temporary use variance?
You could place a condition on the use variance that requires him to take substantial steps towards building the building. So obtaining a permit within 90 days would be entirely reasonable, and perhaps after that he gets an additional 90 days if that's what he needs to construct the building. But if, to the extent you all think that's reasonable, that's one way you could address it.
I think it's reasonable. As long as he shows good faith getting forward and moving on with it, I'm satisfied. Now, I don't know, I'm not gonna extend it beyond 12 months or something, but he should be done way before that.
We are in the building season,
Yes.
clearly.
And I know we may be getting condition deep here, but I would suggest, if we were gonna be doing this, that a movement of the containers there now, perhaps behind the 2019 Oxford State Road, or somewhere more out of sight, I would think would wanna be a condition as well. As far as if we're gonna be permitting a temporary use, then we want it to look a little bit better.
Any other comments as we put together a motion, or?
Somebody,
Well, I know that, you know, in terms of this timeline again that we're granting, I know we've talked about the 90 days, and legal counsel has mentioned, you know, what would be a reasonable way to word that in terms of, and you've talked about permitting within 90 days, but just trying to find a reasonable timeline for this to, I mean, I think that we're certainly trying to help you to get your business started. But again, I want to point out this timeline again. You know, building burns down in 2012, whatever hardship that we're talking about financially. I mean, we're talking about something that goes back at least 2014, 2015, and then even within the last year, really no effort to do much at this facility that we can see in the record to do something about the containers. So I'm hesitant to extend that timeline myself. I need to see, you know, I want to see some movement. What conditions would we like to place?
construction to start in within 90 days or something.
But he said he can't do that within 90 days.
And I said, what if I talk to a builder and they're 3 months booked out already? Well, like you said, it's the start of the build season. So what if I go pay a builder for the barn and they're constructed and they say, oh, we can't start for 3.5 months? That's all I'm saying. That's why I'm not for extra.
I think clearing that base foundation you got and getting the stuff out of there is showing progress. And that's what we're looking at this point. You progress getting your job, building it done. And that, to me, is good faith, clearing that area out and dressing it up and whatever we say as far as push it away from the street, put it in a container, just one container, or as I said earlier, if you fence it where you can't see it, just make some gesture that shows progress. Now, I can't address whether a builder's gonna say 100 days or 3 months or 6 months, you know, that's what bothers me.
I would argue that we just need to be very narrow on what we're allowing here. I think that 90 days is what we have in the code. If you find someone that you're going to work with and you have good faith effort, I think you can come back to James and others, and that would be a question for an extended time, whether it comes back before the Board of Zoning Appeals or whether it goes through the administrative process. But there has to be some indication that this timeline is moving forward. I think from the city's perspective as well, that, you know, that's an important part of us working together to see that you can do something that's within the code. Otherwise, we're just kicking the can down the road. It's not solving the problem for the city, it's certainly not meeting the code. I don't think that we would be doing our job if we were to extend that timeline too far.
So if he were to obtain the permit, clean up the site, and then show some sort of documentation with a quote and a deposit or something within 90 days, regardless, I don't want to say regardless of when it's constructed, but, you know, we're assuming a builder would be able to get to it in 6 months, but within the initial 90 days, if he can show when that's going to get constructed with some sort of financial commitment, would that do it?
I don't know. If Mr. Metz, so let's say that he walks in and he's going to obtain a building permit. How long is a building permit how long is that building permit? Is it 12 months from that point forward?
For a zoning permit, it'd be 12 months.
So
You'd have
within
12
90
months.
If you come back within 90 days, you ask for a zoning permit, that gives you a year to build your building.
Well, I think she's on the right track, because he would want to enter into an agreement that says that the building to be completed by.
Right. You know, he needs to go somewhere, pick a builder, have them say when they're gonna get to it, and then have, you know, show that the cost and the financial commitment, I don't know if there needs to be a down payment, I would assume there is, and show that that's been scheduled.
And bring that to the city.
Right.
How big of a building are you contemplating?
30 by 40, the same as last time.
30 by 40? It's not a big one. It's 1,200 square feet.
That's all I need. I don't need any more.
I can't believe that it can't be constructed by August. I just,
I can't speak for the builders.
I know, I understand that. But I think we need to have, if we're gonna ameliorate your problem here by allowing you some type of concession towards building, we gotta have a contract with down payment and other than time constraints. It's ready to go. That's when, I'm looking at 2013, when did this fire happen? I think I remember it.
I'm not trying to blank it out.
I know, but, well, you can't blank it out. When did it happen? 12?
I think it
I
was
think it's 2012.
2012.
Yeah.
article.
Yeah. In fact, I think I specifically remember that happening. But, 30 by, I'm trying to think 30 by 40. Probably everyone in this building right now has a house that's larger than that, so I can't imagine you can't get that building done, or at least have a committed contract for construction with the required deposit to be placed down.
Payment's not the problem.
Well, since 2013, seems to have been an issue, or at least until you received the violation notice, which I think was in 2019? When was the first notice of violation? I can't go back through. Of 23?
Yeah.
Okay,
No. Yeah, this year. First
this
one I
year,
got one. Yeah,
okay.
I
Okay.
Mr. Moore,
Yes, sir.
if I could say one thing, when you, whoever makes the motion, you are gonna make a motion to approve or deny or whatever, I would just like the motion to include the following criteria, like that all the following criteria are satisfied for the use variance. So the applicant, for use variances to be approved, the applicant must demonstrate such hardship by clear and convincing evidence that all of the following criteria are satisfied.
Right.
Whereas area and dimensional, you can pick one. With a use variance, it must meet all. So whoever makes a motion, you could say that, you know, there has been clear and convincing evidence that all of the following criteria are satisfied, and then if you would want to make any modifications to that.
Another alternative might be, since Mr. Baker realizes now that his feet are to the fire, if we were to continue this hearing for 30, 60 days, is that within our prerogative?
I believe you would have the ability to vote for a motion to continue for next month. And then beyond that, I am not sure.
Because I fear that we're not going to be able to satisfy A through F as a criteria for a use variance.
Question on that continuance. What would be his actions that he could do in 30 days if the city's holding him up?
That's up to he and council. This motion, this variance for a use variance.
He's stating that the city's holding him up from filing the permit.
That I can't answer for the city.
Well, but what would the continuance do then? It would do nothing but delay things 30 days. Because the city's still gonna have to grant the permit.
The evidence right now is that there is no impediment to Mr. Baker acquiring a certificate to get a permit. That's the evidence before us right now.
We now know that was just a misunderstanding.
Is that what the city?
I understand, Mr. Baker, but Mr. Metz has indicated that there is no impediment to you getting a certificate for construction.
Mr. Cash, I believe there's the issue of what would be the purpose of applying and getting a certificate of zoning compliance and going through the building permits for a commercial building if he wouldn't be able to receive the use variance to continue to operate his commercial facility.
Catch-22, yes.
That's the catch that they've been operating on.
It is.
And additionally, I would like to say that since they did apply, there has been a stay, meaning that there's no more code enforcement activity or zoning violations accruing. So when their application started, there's been no new activity that's been taking place on that property.
Understood. I can see that dilemma there. Oh, shoot.
I want to reiterate, we did close the hearing at this point, did we not? We've had a lot of comments going back and forth. I know so the public hearing has been closed. We're deliberating at this point, just to,
If I may, you may want to allow the applicant just to present any closing statements they might have. They've been fielding a lot of questions and really gotten to present on their own. So
Sure.
if you all
I believe everything that we intended to present has already been covered and is in the submission, unless there's anything else that Mr. Baker wanted to add, but I think we've probably covered it pretty thoroughly at this point.
I think we ought to let them have their seat, and I think we ought to deliberate and make a decision.
Yep.
yeah, I don't think there's any other questions that we have for you. We just need to talk for a moment.
Thank you.
Thank you very much. Well, again, let's go back. We have two issues on the table here again. You know, we have the actual property itself, the variance, whether we want it to allow a use variance for the property. And then we have this question that seems to be taking most of our time about what to do about the accessory structure. Again, when we look at the overall property itself, I think it's reasonable to say that it certainly leans more commercial than it does residential at this point.
Yeah, I can vouch for what the gentleman said. I've been here since I was 4 years old. Had some friends and relatives, some fine people who grew up in a reservation, as it's known, and
But here's,
that's been commercial.
but this property itself, this question I have, we've got, this case is just confusing all around. We've got two locations here, 2019 Oxford State Road, and then we've got 3228 Omaha, which seems to be a residential. One deed, but we've got two streets, and we've got this, can we have some clarification on that? I mean, clearly, we have this, as it was annexed from Lemon Township, we know that it's non-conforming uses, but there is it's a mixed-use neighborhood, I imagine, at this point. So we can still move forward with that, looking at Part A of this question, whether or not that we would allow a use variance for the two residences on the lot. And then we have the second question, again, looking at these structures. Now, if we could, I think, Mr. Metz, what you were saying is if we're going to modify this, we would have to say that it meets the hardship criteria, clear and convincing evidence that it meets all hardship criteria. Is that correct? Before we would enter into any kind of other conditions?
So to grant a use variance, which is what you would be doing, the applicant must demonstrate such hardship by clear and convincing evidence that all of the following criteria are satisfied.
So then we got Part A of this question, and whether or not, so do we want to look at these two separate and just make a motion on this first one? Let's get this out of the way for this first part of the question. So if we're going to make a motion on whether or not we would allow the use variance for these two locations, 2019 and 3228 Omaha, seems that there's consensus that we would allow a use variance for that. Is that correct? Does there seem to be consensus moving there? Would anyone like to make a motion that this meets the review criteria with clear convincing evidence? And we'll answer that first part of the question.
I'll make a motion. I move to approve the variance request for 2019 Oxford State Road and 3228 Omaha Street, citing and fulfilling all the variance review criteria.
Clear and convincing evidence.
Clear and convincing evidence.
I'll second it.
Okay, we have a motion and a second.
Gary Gross,
Yes.
Jim Hall,
Abstain?
Todd Moore,
Yes.
Christopher Ambergy,
Yes.
Jerry Heidenreich,
Yes.
David Cash,
Yes.
Stefan Wanamaker.
Yes.
Okay, so we've established now that the use here is commercial in nature. Now let's move to this second part of the question, which is a little more complicated. Review criteria would still have to be met on the second question. Is that correct?
Get your pen out and write them down. I'm serious.
So we still, with looking at whether or not that these structures that are there, whether it meets the review criteria, this is where it gets a little more complicated, I think, for us.
Mr. Chairman?
Yes.
May we start with the last one first? That'll be removed at the end upon completion of the new building?
Well, first of all, we have to determine whether or not that those permanent structures that are there, as are defined now in violation of the code, whether or not that meets the use variance criteria.
Is that correct, to use the same criteria for the shipping?
Have to use the same criteria. In my view, it does not meet the criteria. What we're asking is to allow a variance, a use variance, for prohibited containers.
Temporary.
Is that true, though, under the commercial storage? Was it permitted? That was the 90-day under commercial.
Right, so that's what we would have.
Temporary
So we have to figure out if we're going to modify that in some way, but if we're calling this a temporary storage, this is where, am I correct, that we would offer conditions to the hardship criteria?
I'm sorry, could you say that again?
So in order to go down this path of trying to figure out a remedy, we have to call it a temporary accessory. Is that correct? Because right now, it's a permanent accessory under the code. So the question would be whether or not that it meets the use variance criteria. We have to satisfy the use variance criteria first. Or can we make modifications?
So you wouldn't be modifying the use variance criteria. It would have to meet all of the use variance criteria, but then you could place conditions on your approval.
Okay, that's the question that I have. Mr. Cash, you're usually pretty good at putting these motions together. Can you at least jot these down as we kind of look at this? Or who wants to take note of how we might want to do this?
In my opinion, if we were to, I agree with you. I don't believe that this use variance request complies or that the criteria is satisfied, all of the criteria. But if we were to, and I'm not in the position to make the motion, but anyway, that's as far as I'll go.
Okay, sure.
I guess I will interject if I were to, well, I'll make a motion. I'll make a motion that the use variance be granted subject to the condition, and that the review criteria are satisfied subject to the condition that these temporary trailers, storage containers be removed within a 60-day period.
Well, the code allows 90 for
I
temporary.
understand that, but I don't see any reason, I'm making it 60. I don't see any reason why they can't be removed within 60 days, and a certificate for, at that point in time, I believe that that the property would be in compliance, and Mr. Baker then would have the ability to apply for.
I mean, but he's not gonna have the building built by then, probably.
But that's not the question. The question is whether the storage containers need to be removed. Once they're removed, the property is in compliance, correct?
Yes.
The property technically would be in compliance because we've already given a use variance. We've moved for a use variance for the operation of a commercial operation. The only issue now becomes these storage containers, and if the storage containers, obviously they're portable, they were moved, they can be removed, and then Mr. Baker is free to, at any point in time down the road, to apply for a certificate of construction for a new building.
Hold on a second. If he removes what would happen theoretically, he removes the trailer and just leaves the appliances sitting there. You just said you gotta remove the trailer.
I don't know that, I don't know that that's part of the violation, is that the appliances are out there.
Well, is that a practical solution?
Well, Jerry, now we're running into the other part of our obligation. I mean, we have an obligation to honor the code too.
Well,
We're trying to help this guy, but we can't deny this either.
I don't think he has.
No, I wouldn't.
He's already addressed that, as far as I'm concerned.
My motion was that the use variance review criteria have been satisfied, subject to a condition that the storage containers be removed within 60-day period, which would be effective July 3rd, July 4th, whatever that would be. And at that point in time, once they're removed, there's no violation pending.
My hesitation to that would be his operation of the business from the 60-day mark until the building is completed. He made it.
But we've already voted on a use variance for the operation of the business as a commercial operation, correct?
Correct.
Didn't we just vote on that? Yes.
But as far as, I believe his issue was having a place to store his inventory so he could operate the business, I guess, properly in his eyes. So I don't know if maybe an extension for maybe not 30 or 60 or 90, but some time frame, again, like we have been speaking about before, to show some good faith. I mean, I think a permit, plans, design, deposit, quoting, site clearing, all that could be done, I think, well within a 90-day timeframe. Well, probably within the 60 days. Just a matter of what happens after that time.
I had a thought. He said that he could get by with one shipping container and consolidate it. What if we had one removed now and allow the other one to stay until the building's completed?
Don't know that you want to leave that open-ended. I think the completion of the building needs to be
Well, we'll know that when he gets the contract, what the
Well-
completion date is,
no, it's,
because that's part of the agreement. And that'll be the same date that the other shipping container would have to be removed.
I was gonna say that, just, again, making a suggestion here. I go back again to 120602 D9. And what I'm looking at there is the maximum allowable time is 90 days for temporary storage. I do think that it's a good recommendation for one unit if we're going to go down that path. If we were to go down that path, I think one unit only, and one unit only for 90 days. That would be subject to moving that behind the facility, and that would be as far as I would be willing to go.
I'll amend my motion to extend that to a 90-day period then,
And one,
And one container.
and one container.
thank you.
Okay. So the motion, do we need to restate that, or is?
Could you please restate that for the record?
My motion would be that the use variance be granted subject, and that all of the review criteria have been satisfied with one condition, that the temporary structure for storage be allowed for the code period of 90 days. One structure
Structure, yes.
be allowed for a 90-day period.
Are we saying to move that as well?
My only concern with that motion, which I agree with the motion, except for what happens after that 90-day mark, is my only concern that I think might need to be addressed, unless we just leave it up to,
I think we'll be back here for another application for a variance, because at that point, it'd be in violation of the
Code.
the variance which was granted.
and then I would imagine by that time, the applicant would probably have a solid plan and a contract and a design and permitted.
I'd hope.
I do have a question for legal on this one, though. When we say that all this criteria is met, that all criteria is met, they come back in 90 days, we're giving them a conditional use? Is that correct? We're giving them conditional use. So you're saying that if we were to go forward with this motion, we are saying that they have met all use variance criteria?
They would have to meet all the variance criteria, yes, to get the use variance, and you place conditions on it, but it's not a conditional use, it's still a use variance,
Right.
it just has an expiration
Right.
date.
So, but it does expire at 90 days, is that?
That's the condition you guys set, yeah.
Okay, I just want to be clear on that 90-day
Yeah,
timeline.
good point,
Yeah.
good point.
Okay, so we have a motion,
Motion?
we have a 90-day timeline, and the motion, I think, has been stated. Do we have a second?
Second,
Okay, motion is second. Roll call, please.
Stephen Wanamaker,
Yes.
David Cash,
Yes.
Jerry Heidenreich.
Could you read the motion to me again?
What I have written down is that David Cash made a motion to approve of the accessory structures for one structure to be permitted for a period of time up to 90 days for it to be moved behind the current 2019 Oxford State Road building, and at the end of 90 days that this use variance would expire.
Thank you, I vote yes.
Christopher Ambergy,
Yes.
Todd Moore,
Yes.
Mr. Hall, do you abstain?
Abstain.
And then Gary Gross.
yes.
Okay.
Okay, just a moment as I move to the next case. Okay, this brings us to case number 123, a request by the applicant at 2207 Oxford State Road for an approval of for approval of an appeal to an administrative decision for the property located at 2208 Oxford State Road. And Mr. Metz, I'll let you give us the overview of the facts.
Thank you. Okay, so tonight before us, we have our first appeal case of the year, as well as a second use variance request case tonight, both for the same property at 2208 Oxford State Road. Public hearing appeal case number 1-23, a request by applicant 2207 Oxford State Road LLC for an appeal to an administrative decision for the property located at 2208 Oxford State Road. The property is zoned R4 attached residential district. The appeal request is for a code violation for shipping containers used as storage where the Middletown Development Code states the use of portable containers, shipping containers, and semi-tractor trailers used for storage without wheels will not be permitted or shall not be used as permanent accessory structures in any zoning district. This is an appeal slightly different than a use variance, and well, very different than use variance, and we'll get into that a little bit later. Variance case 623 is for a request by applicant 2207 Oxford State Road LLC for approval of a use variance for the property located at 2208 Oxford State Road. The property is zoned R4 attached residential district. The purpose of the R4 attached residential district is to provide for moderate to high density residential development, generally located in the core area of the city that reflects the historic urban pattern in and around downtown Middletown. Here's the property. Middletown Development Code, Chapter 1206-01, Accessory Uses and Structures, C1, states, except as provided in code, the use of inflatable garages, portable garages, temporary structures, as defined in Section 1206-02, temporary carports, portable containers, shipping containers, and semi-tractor trailers used for storage, with or without wheels, shall not be used as permanent accessory structures in any zoning district. The picture below was captured by one of our code enforcement officers indicating shipping containers on the property. Here's a property in June 2013. Here's the property in June 2019. Here's the property in 2021. And then here's the property in September 2022. Please note that this is a residential building. The main use of it is residential. They're not asking for a use variance to conduct any commercial activity. This is strictly residential building, residentially zoned. Per the Middletown Development Code, the requirement for legal notice for variance requests, meeting notice letters for the proposed variance were sent to all property owners contiguous and directly across the street or public right-of-way, and no comments were received. So before us, we have an appeal case, and then we also have a use variance case. This stemmed from a code enforcement violation letter that was sent to the property owner. They are appealing a code enforcement officer's violation letter stating that although there was a shipping container on their property, that they were not in violation of the development code. For that set of criteria, there is the appeals review criteria. A decision or determination shall not be reversed or modified unless there's competent material and substantial evidence in the record that the decision or determination fails to comply with either procedural or substantive requirements of this code. I provided you the zoning violation letter that our code enforcement and Jackie Brewer sent the applicant, including pictures showing that there were shipping containers on the property. The appeal is simply stating that they were not in violation of the code. Now, we also have a use variance request by the applicant requesting to have shipping containers on the property. And I'll read that. In order to grant a use variance, the BZA shall determine that strict compliance with the terms of this code will result in unnecessary hardship to the applicant. The applicant must demonstrate such hardship by clear and convincing evidence that all of the following criteria are satisfied. The property cannot be put to any economically viable use under any of the permitted uses in the zoning district in which the property is located. The variance requested stems from the condition which is unique to the property at issue and not ordinarily found in the same zone or district. The variance requested cannot otherwise be resolved by a zoning map amendment, or a zoning map amendment is not the most beneficial approach. The essential character of the neighborhood will not be substantially altered as a result of the variance. There is an existing structure that cannot be reasonably used for a permitted use or conditionally permitted use in the applicable zoning district. The proposed use is listed in Table 1204-3. The hardship condition is not created by actions of the applicant. The granting of the variance will not adversely affect the rights of adjacent property owners or residents. The granting of the variance will not adversely affect the public health, safety, or general welfare. Any person or entity claiming to be injured or aggrieved by any final action of the Board of Zoning Appeals has the right to appeal the decision to the Court of Common Pleas as provided in Ohio Revised Code Chapters 2505 and 2506. So just to recap, we have an appeal in front of us. This appeal is for an administrative decision that was presented by a code enforcement officer. She wrote the zoning violation letter for 2208 Oxford Road because there were shipping containers on the property. They're appealing the decision of the code enforcement officer's decision to write them a zoning violation letter for having shipping containers on their property. They are also asking for a use variance to allow shipping containers on their property. The appeal goes with the appeals review criteria, and the use variance that would allow them to have shipping containers on their property. The review criteria is here under the use variance. Do you have any other? Do you have any? Nope. Okay. The applicant is here, and I end my staff report.
I do have a question. So we have this separated in terms of the appeal and then case 623. Are we moving this forward together, or are we going to narrowly focus on the appeal first, which I think would probably be best if we did that first?
That is entirely up to you. It is the same property.
I wondered too, which comes first, chicken or the egg, but.
I think since it's an appeal, that we should treat the appeal as an appeal. Let's listen to that case first before we move forward with 623. Yeah.
That sounds great to me.
Okay. I agree. Okay, this is a public hearing. Anyone wishing to speak in favor or appeal the case, please come forward.
Do you two solemnly swear the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You'd identify yourselves too as you speak.
My name is Andrew Meyer, counsel for the property owner. That's Smith, Meyer, and Webb. And this is?
I'm Justin Dew. I'm the managing member of 2207 Oxford State Road, LLC.
First, with respect to the appeal, I'm going to let Mr. Dew do most of the talking as to the reasons, but I sat here, obviously, and observed what you guys just did and what you heard the other applicant talk about. Obviously, we're aware of what the code provision says, and you may be wondering, why in the world are these guys in here on an appeal for a code violation when there's shipping containers on that property, and you saw a picture of it. I want to talk about not a bunch of words, but concepts, and I think this gentleman hit those concepts right on the head earlier during the other applicant's process. In this city, I don't live in this city, I know lots of people that do, my boss is from this city. In this city, there's lots of shipping containers. He has pictures with him tonight. And from our perspective, this enforcement decision has been selective and directly impacting only certain individuals. There's shipping containers all over the city, and if there's a code provision that says no shipping containers, then they shouldn't be anywhere in the city. So from an appellate standpoint, what we're really talking about is selective enforcement here, and only selecting out certain individuals and certain properties. And so that is really the basis of the appeal. And I'll turn it over to Mr. Dew to show you the pictures that he's taken of the various shipping containers that are on other people's property, city property, school property, everywhere else. And he also knows people who have shipping containers that haven't received any code violation letters from the city. And so he can tell you about that too.
Anything that is shared with the council or with the Board of Zoning Appeals needs to be given to me for record retention.
All right, we'll give you copies.
Thank you.
For starters, I grew up here in Middletown, been here my whole life. My father's a small business owner. I'm a business owner. It is always my intent, I own multiple properties in Middletown and Westchester and some in Dayton, to keep our properties nice. Part of the leases that we write, we always take care of the yards. We always cut the grass. We're not here to be a hindrance to the city. We want to be part of the community, and we've improved this property vastly. You know, par for the course, I think there's 4 junkyards on Oxford State Road right through that section. There's one right across the street from him. When they came down earlier this year, it was cold and we did have some stuff that was out front, but our containers are in the back. 2 of the 3 are painted to match the building. So, you know, we're doing our part. We've put a lot of money into the building. And it is selective enforcement. I mean, I know multiple business owners in this town that have containers on their property. There's nothing being done about it. They're not getting any letters, from the big companies to the small ones. Plus, I mean, we're at a time of great inflation. I mean, a shipping container is $3,000 or $4,000. It's wonderful storage versus, you know, building a stick building. I mean, you'd be lucky to have a pole barn built in 6 months right now, trying to get permits and doing all those things. The workforce in this country is garbage right now. You know, there's so many things that it just simply doesn't make sense. Shipping containers are part of culture. They're building houses out of them. I'm a commercial contractor. I've been part of 2 different restaurants that were built out of shipping containers. This is coming, and, you know, this is, you know, it's just, it is what it is. There's shipping containers all up and down Oxford State Road, and they're all over this city.
So give the gentleman back here the pictures that you want to show the board, so he has them.
You can share with them first. I just need a copy at the very end.
So these are just pictures of our property today that were taken.
While you're passing that out, I'd like to ask, we go back to 120602 D9.
These are the containers that the city has on city property.
I don't know why I'm doing that.
There's a table in that section that talks about temporary storage, because I do want to differentiate between temporary and, you know, in this table, we see construction trailers and offices. We see temporary storage, allowable duration. That's 120602 D9 again. When we think about these, you know, you're passing out, I haven't seen these yet, but I mean, you have done a lot on this property. It's very clear that you have done a lot over the time, over the timeline that you've looked at this. It's certainly, you've done a lot. I think it looks, you've made an improvement to the property, no question about that. When we look at these current units, what are you doing with those units now?
I use them for storage.
So it's just an economically feasible way for you to store. What are you storing inside those?
Just, I mean, I've got from materials in them to, I've got a tractor in one of them.
Okay.
I've got a lawnmower in one.
The current business, what type of business do you do there?
So I just store stuff there. My nephew actually lives in the house.
Okay, so someone lives at the house, and then this is just a location that allows you to excess storage. You put things in the units. Seems like a reasonable place to store tractors and other things.
And that goes more towards the request for a use variance, not necessarily the appeal. I mean, I consider.
Well, I want to stay focused on the
Yeah.
appeal for a moment, because the question is whether or not that Mr. Metz or others erred in their application of the code. So is there a difference, council, between a construction zone and a storage unit for tractors and other things? Is there any difference
I
between those?
can't disagree with you that there would be a difference between those two types of situations.
Okay,
How long something's been there, I don't know. I know this gentleman has seen those shipping containers for much longer than what these code provisions say up here, but I can't disagree with you.
right, so as a residential lot, we clearly know we're not practicing commercial uses there. The intent is not to ask for a use variance there. It's, at this point, there's no question that you want it to remain, at least the intent is for it to remain residential, correct?
Yes.
So the storage unit itself, has council looked to whether or not that under, whether you call it conceptual or not, whether or not that this particular storage unit is even in compliance with any part of the code? Because it's not. That was the case, the last case that we had. These particular storage units that we're talking about, they're not, you're asking to use them permanently as storage, lawnmowers, et cetera. So we have to differentiate between what would be a temporary use and something more long-term on a residential site, not a commercial site like the previous case.
Correct. Your differentiation.
So what is the fundamental error that the city made in saying that to allow something to go long-term in that, to be stored in that particular unit, what is the problem there? Can you explain that? You say it's arbitrarily being applied,
Well,
but
yeah, that's the basic argument that, and it's more procedural in nature. It may not be substantive because the code provides for both procedural problems and substantive problems. And so from a procedural standpoint, if the city is only selectively enforcing the code provisions against one person versus others, then I would consider that to be a procedural defect in how the city is going about enforcement of their code provisions.
and what might we look to as a board for evidence that there's some selective, arbitrary nature to what the city's doing?
Mr. Dew just provided you with some photos of other locations where these things exist, and he can also tell you about the individuals he knows that have shipping containers on their property too, and have never gotten letters. So those pieces of information I would consider evidence as to what the city isn't doing for some people or businesses, et cetera, and what the city is doing to other people, like Mr. Dew and the other gentleman that was here previously. So again, from a procedural standpoint, I would consider that a defect in enforcement of the code provisions.
Thing,
The question I would have is,
Yeah.
you're on a residential property. Some of the pictures I saw were either commercial or some other classification of zoning. So that to me would, if he could just present his case on residential situations that have these trailers or storage units, whatever, then I would feel more that he might have some sort of standing there.
Well, as the chairman pointed out during the last case, the prohibition is blanket. It's for every zone, not just residential zoning. Commercial, industrial, residential, all. Chairman pointed that out. I think it's in the code. So it's across the board. And so if it's across the board, then the city needs to enforce it across the board.
It's across the board in terms of whether or not we're talking about temporary versus permanent, and then residential versus commercial. It wasn't a blanket statement. There is some nuance to that argument. So when I say these particular units that we're talking about, which is, I'm not exactly sure what to call it at this point. It's certainly, it's not a pod. I mean, these are
It's a
industrial.
two 40-foot high cube shipping.
Right. So if we look at what would be allowed, there are things that are temporary in nature, and that goes back to what we're talking about in 1206.2. So there's a whole list of items that you can see here. That there's not an absolute prohibition on any type of temporary storage, but what's being asked here is a type of storage unit in itself that is prohibited. It's not within this table. The second part of that would be the duration. It gets a little more complicated. I mean, it's, for instance, if you wanted to put a pod, there's part in the code that certainly allows a pod there. So if you have temporary use and you want to put a tractor and something else there, The code allows you to do that up to a certain time frame. If you're in a construction, if you want to do construction on your site, then there's code that allows for you to put something there that's temporary in nature. There's the ability to expand that through zoning compliance. So it's not an absolute prohibition, but what we're talking about here is allowing the type of storage that you have to be permanently placed there. There's some nuance in that.
There is. I don't disagree with that.
So for me, the question would be the type of storage that you're proposing on a residential site. Not saying that you couldn't do anything there, but the idea that you would use that type of storage unit permanently, that's where I have a little more trouble with that, and whether or not that the city made. Whether they selectively did that or not, I have no ability to actually say that they did or did not. Okay, procedurally, I don't have any evidence or otherwise. How am I going to have a rational argument for whether or not they did or did not? But I just want to point that out, that we have to, again, kind of make the distinction of what you're asking. What you're asking is on a residential site to have a storage unit that would be prohibited within this table, conceptual or otherwise. It's not within the code. Whether it's on your site or any other residential site, it would be prohibited. That type of unit in itself.
Mr. Moore, I just want to say one thing real quick. Currently, the conversation you guys are having is a little bit more geared towards the use variance. And that is, as you guys asked, that would be a little bit later on. Currently, what's before us is there are shipping containers on the property, as you can see in the pictures that he provided you, in the pictures that were provided by the code enforcement officer who wrote the violation, the letter that was given to you by our code enforcement officer, and then additionally the images that I showed you. Now, the development code strictly states that temporary storage structures such as this are not used there, are not permitted as permanent storage. The appeal is simply stating that the city administrator, or the code enforcement officer, was in fact incorrect in writing the zoning violation letter. So that's the first part that we talked about. That's the appeal. The conversation you guys are having is a little bit more geared towards the use variance. And then I do have some follow-up statements for that as well, just for some clarifying points. But for this, the review criteria, how you should make your decision, what should guide you in your decision, should be the appeals review criteria. Which is this: a decision or determination shall not be reversed or modified unless there is competent material and substantial evidence in the record that the decision or determination fails to comply with either the procedural or substantive requirements of this code.
So my take on what you just said is we're here on the appeal that the zoning enforcement officer erred in sending them an order for their letter, right?
That's correct. You're only here to determine what, for the appeals case, not for the use variance,
Right,
for the appeals case. You're only here to determine whether or not our code enforcement officer, Jackie Brewer, was incorrect in sending the zoning violation letter for a shipping container when there's been provided evidence that there was a shipping container in error of the code.
Okay, so I'll ask you, were those pictures they showed of your property that the code enforcement officer show shipping containers on your property? Okay. That's all I have.
I would move that the appeal be denied.
I second it.
Any other discussion?
Well, the public hearing is still going on.
Say we're,
But I believe the motion can still stand.
I was going to say we are moving quickly, but any other questions for council before we? At this point in the hearing, this is a public hearing, so is there anyone wishing at this point to either come forward to speak again in favor for us to review this criteria for the appeal. Does anyone wish to supplement the testimony that we have?
Why are they prohibited?
Do you wish to be sworn in?
Yeah.
Okay.
Come forward, sir. Raise your right hand. Do you solemnly swear that the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And identify yourself, please, sir.
I'm Sam Barnett, and I live at 2207 Oxford State Road, which is directly across the street. I just want, why are they prohibited? I mean, I understand there's got to be regulations on them. You could have people stacking them 3 or 4 high and doing crazy stuff with them. Why are they just say they're prohibited? Why aren't there just regulations on them?
That's not a question that we can answer.
We might have that
Well,
same question.
if I may, because council passed it.
That's true.
That's the truth, though. That's the
Yeah.
accurate statement. Made it a part of our code. That's the plain truth.
It just, with everything that goes on Oxford State Road, it just doesn't make any sense why it's a big deal.
It's a unique place. You know.
Yeah, I mean, we got a slag hill
It is. It's something that,
behind us. We got a coke plant on one end. We got a steel mill on the other end, and the traffic and stuff down
if
through
you
there.
ever get the city to have a public hearing on it, I'll come and speak for you.
I mean,
It's a very unique place.
Yeah, I've lived there my whole life. I grew up on Andrew Street. I lived on Oxford State Road for 16 years. I'm a councilman, or not councilman, but a trustee at the Eagles next door to the property there. My whole family lives around.
But the answer to your question is because city council passed it.
The city council, can they do anything to revert it?
Oh, sure.
Redo it? Because it seems like shipping containers are gonna be part of the future, because I mean, they just are. I mean, it's.
That's who you want to address.
With the way stuff is, I mean, it's cheap storage for people, and it's economical right now, because you can't get people to work. You can't get people to build some materials through the roof. Everything just keeps going up, and storage containers make sense.
I assure you, sir, the city will hear about our meeting here tonight, and they'll start working on this.
Yeah.
We got a
Yeah, they need-
representative of
they need
government,
to.
call your councilman.
We can't change that.
Anyone else wishing to speak on behalf of the appeal, please come forward. Anyone wishing to speak against the appeal, please come forward. Okay, seeing none, I will close the public hearing. We'll move to deliberation. If we have any other questions for council or for the property owner, let's do that now. Okay, seeing none. Okay, the question again was whether or not there was some procedural or some substantive error in this decision. I know that we had a motion earlier, if we could restate
I
that
will
motion.
make a motion that the appeal be denied.
And I second it.
We have a motion and a second. Can we have a roll call, please?
Gary Gross,
Yes.
Jim Hall,
Yes to deny.
Todd Moore,
Yes.
Christopher Ambergy,
Yes,
Jerry Heidenreich,
Yes.
David Cash,
Yes.
Stefan Wanamaker.
Yes.
Now we're moving on to the use variance.
So this is a public hearing, case number 623, a request by the applicant at 2207 Oxford State Road, asking for approval of a use variance for the property located at 2208 Oxford State Road. Mr. Metz, I'll let you state the facts. I know we've gone through some of this already, but just, again, restate for the record the variance itself and what's being requested.
Absolutely. So tonight before us, we have a request by applicant 2207 Oxford State Road LLC for approval of a use variance for the property located at 2208 Oxford State Road. The property is zoned R4 attached residential district. The variance request is to allow shipping containers for storage, where the Middletown Development Code states the use of portable containers, shipping containers, and semi-tractor trailers used for storage with or without wheels shall not be used as permanent accessory structures in any zoning district. Property zoned R4, which is an attached residential district. Chapter 120601, accessory uses and structures, C1 states, that temporary carports, portable containers, shipping containers, and semi-tractor trailers used for storage with or without wheels shall not be used as permanent accessory structures in any zoning district. We've touched base on the previous case, and we touched base on it in this case, that it would be permitted as a temporary structure for a period of time no greater than 90 days. It's not uncommon for us to get certificate of zoning compliance applications for commercial buildings or for residential districts to have a shipping container for a period of time. We do approve them. When it's for residential, it's up to 14 days, and when it's commercial, it's for 90. That is very common practice in the city, so oftentimes when you drive around and you see shipping containers behind, I don't know, let's say Tractor Supply, for an example, they most likely got a certificate of zoning compliance for that. Here's the property in June 2013. Please note that this is a residentially zoned district and it's still being primarily used as residential. I would also like to add that in these pictures, you'll see like a tractor, or you'll see a truck, or you'll see a dumpster or whatever. That is the applicant's right. He's not able to have it within his front yard or within 35 feet of the public right-of-way. So this case, it'd be 35 feet further back. So he'd be allowed to have these items in his yard. It's not the fact that he's not allowed to have a boat or a tractor or a lawnmower or a dumpster or any of those things. He would be permitted to have those. It is solely just for the shipping container. I just want to make sure we're clear on that. Here's the property in September of 2022. Please note that they appear to be back 35 feet. Once again, it is the shipping container. And for the use variance, we will, to approve a use variance, the applicant must demonstrate such hardship by clear and convincing evidence that all the following criteria are satisfied. The property cannot be put to any economically viable use under any of the permitted uses in the zoning district in which the property is located. The variance requested stems from a condition which is unique to the property at issue and not ordinarily found in the same zone or district. The variance requested cannot otherwise be resolved by a zoning map amendment, or a zoning map amendment is not the most beneficial approach. The essential character of the neighborhood will not be substantially altered as a result of the variance. There is an existing structure that cannot be reasonably used for a permitted use or conditionally permitted use in the applicable zoning district. The proposed use is listed in Table 1204-3. The hardship condition is not created by actions of the applicant. The granting of the variance will not adversely affect the rights of the adjacent property owners or residents. The granting of the variance will not adversely affect the public health, safety, or general welfare. Any person or entity claiming to be injured or aggrieved by any final action of the Board of Zoning Appeals has the right to appeal the decision to the Court of Common Pleas as provided in Ohio Revised Code Chapters 2505 and 2506. Additionally, I would like to state that as it's residentially zoned and it is being used as primarily residential building, he would be able to have a shipping container for up to 14 days, once a year. If it was then transferred to a commercial, it could be up to 90 days, once per year. The applicant is asking for it to be a permanent structure. That ends my staff report, and the applicant is here.
Well, again, this is a public hearing. You were sworn in earlier, so we won't make you go through that process again. But is there any intent at some point that you would potentially apply for this to be a business? I noticed that all of that is you have, a lot of rock there. It's not, it's not a front yard. It certainly leans more towards a commercial property and being on Oxford State Road. Is there intent long-term that you would do that there? Or?
We're touched by I-2 now, so there will be changes coming, but, 90-day storage, that's a joke. What am I gonna move all the crap out? 90 days doesn't do anything. These are sitting behind the house. They're painted the same color as the building. The one is not because it come in before it got cold. You know what it looks like if I put everything in them containers out there 35 feet off the street?
I see.
We're doing our part to make things.
I understand.
So tell him what your intent would be if it remains residential. what your intent would be with respect to, for example, two of the shipping containers that may be sitting side by side. What would you want to do? What are you asking this Board of Zoning Appeals to let you do with those two shipping containers on your residential property?
I mean, we'd be willing to truss and roof them over top of them. You know, that's done down at Air Products. They got about 5 of them down there that are strung together with about 60 feet of truss in between them. You know, I mean, these things are sturdier and more economical than any shed that you can buy anywhere.
And so it's an alternative to building a humongous pole barn or something else for individuals who maybe can't afford that, or they don't have the time for that. They can get a shipping container for a certain amount of money, make it look really good. I've seen houses made out of shipping containers, and it can be used for legitimate storage purposes to get all that stuff that this gentleman back here says is permitted out in the yard. What would you prefer? All that stuff sitting out there, or being stored in the back in two containers that look really nice like a barn? So, I mean, I think that is his intent. To answer your question more directly, I don't know what the long-term is for that piece of property. It does touch I-2. Would there at some point in time potentially be a request to rezone or something of that nature? Maybe, but that's not what we're here for tonight, obviously. But I think that's what the intent would be with the structure in the back.
With inflation, you know, and just where things are from the state of the world the last few years, I mean, I would have already built a pole barn there. I mean, concrete wasn't $180 a yard, you know, and lumber wasn't 3 times what it's supposed to cost. It's like the city's putting a strain on regular people. I've got 4 guys that work for me. I'm a small business guy, and they're sitting here saying, oh, you can store stuff for 90 days and turn in the, you know, or you got to, you know, it's ridiculous. It's ridiculous.
I think you're starting to address part of my question too, would be what makes a storage container a not storage container? You know, you're saying they build a roof over it, and does that, in the city's mind, change the intent of the building, or does it make it a building instead of a storage container? What is the definition, I guess, of?
I think it just drives the fact that containers are part of culture. They're building restaurants, houses, you know, there's a lot of different things you can do with them. You're seeing them at some store and locks now. You can cut, roll up garage doors just like on a store and lock in them. I mean, they sell them like that out at BEI, you know, so this is something the city definitely needs to get a handle on, because these things aren't going nowhere. They're gonna be more prevalent.
Does the city allow that?
You haven't been.
Can you get it from
Well,
the-
hey, not your time yet. Just wait.
I think you're presenting the case of.
I'd like to ask a
it
question,
needs to
Mr. Metz. In terms of R4 residential district, in your understanding of the code, how broadly is R4 represented in the city of Middletown? How broad does that touch as a zoning, what are we talking about in terms of scope? How broad does that go in a city of Middletown?
Majority of the city is considered R4.
So we're talking about a lot of neighborhoods, right? So when we look at this R4, where you're currently zoned right now, where we're talking about it being an R4 classification. I understand your predicament, okay? I'm doing the best I can. But when we look at where you're classified as R4 and recognizing how broad that is, let's expand your argument for a moment. Certainly, in other areas outside of Oxford State Road, having a shipping container that side in someone's backyard would probably be unreasonable, would it not?
They're in Middletown now, people.
But they're not in a lot of neighborhoods in Middletown. The majority of neighborhoods are not in neighborhoods. I think that's fair to say. I think it'd be a stretch to say that these, you know, you drive down different neighborhoods outside a certain area of town, you're not going to find something this scope and scale in that neighborhood.
That's possible on lots of lots. We don't disagree with that. But if the lot is big enough and the dimensions are accurate and there's room for it and it makes sense, that's what I think a request for a use variance is for. For you guys to determine whether it's appropriate for this particular piece of property, not necessarily other properties that are out there that haven't come before you to request such a variance.
But it's an R4 classification is what I'm trying to point out.
Yeah.
That makes it very difficult from this side of the table to say, hey, there's a green light, go forward with what you're asking, because certainly would be spot zoning if you look at it from a different perspective, or we make some classification for R4. We have to narrow the
Understand your
question.
trepidation.
So, let me ask you this. If you're unhappy with what is being presented here, are you sure you want to ask for us to decide your case tonight?
I want to put one thing in there. We have over 3 acres of land and over 200 feet of road frontage.
I understand. I understand what you're saying. I think we all recognize you got a large lot. You got an R4 classification where it probably fits better somewhere else. I'm willing to go there with you. I understand your predicament. I'm just saying, do you really want us to go down the path of looking at this question tonight, or do you want to look into this further? Do you want to look at other alternatives? Because the question is really pretty much narrow, whether or not you are, in compliance at this point, which you've already appealed, you've lost the appeal. Now we're asking for a use variance. Does it make sense for us to move forward on this tonight? What do you want to do?
We'd request a continuance for 30 days, with the hearing being in progress.
What was the last part?
With the hearing remaining in progress. In other words, we come back in 30 days.
Okay. Is there a problem with that?
I mean,
Mr. Metz? With the hearing remaining in process, in other words, they have to pay no further fees or anything?
I believe they would be permitted to have a motion to continue. It would be at the next meeting, so the
Yeah,
first
30
Wednesday of
days,
June.
saying that.
Whenever it is.
Right. So move.
Is there a motion and a second? I'm sorry, lost track of who made the first motion.
He did. Chris,
Okay, I didn't hear the second.
there wasn't one yet. I'll second it.
Okay, motion and a second.
Stefan Wanamaker,
Yes.
David Cash,
Yes.
Jerry Heidenreich,
Yes.
Christopher Ambergy,
Yes.
Todd Moore,
Yes.
Jim Hall,
Yes.
Gary Gross.
Yes.
Thank you, gentlemen.
Thank you.
Thank you.
Oh, here are the other ones you need
Yeah,
to,
those go into the record.
these go to the record.
All right, that moves us now to number 7, agenda item, old or new business. Mr. Metz, is there old or new business this evening?
There's no new or old business.
Okay,
One thing I would like to say is that, so these cases tonight came before us from a code enforcement action, right? I'm representing the city as the city's liaison to the Board of Zoning Appeals. I'm here to enforce the development code, and when you guys review an application, you're here to approve it based off of the variance criteria or the appeals criteria. So I'm just want to state that we all have a duty to development code as the code enforcement officer, as myself, and then as the volunteer board. I think we all did a good job referencing the criteria, so thank you, and I don't have anything else for tonight.
I had something I wanted to bring up. Can we direct council to look at this issue with shipping containers, revisit it? Because they're right. It's happening everywhere. There's a program on HGTV of people that have tiny houses, and a lot of times they're shipping
I
containers.
watch it all the time.
Yeah, and it's here. I mean, it's not just coming, it's here.
It is for real.
It's for real. And, you know, when the code was written, it wasn't a big deal. But even though the code's not that old now, but I think that needs to be looked at by council and possibly changed to better suit what's going on.
So-
It needs to be managed properly and regulated.
Yep.
And it can be a very positive thing if
So, Ms-
it's done so.
So, Mr. Gross, there's plethora of different ways. If you'd want to push forward for a text amendment, you can either come to a planning commission meeting or a city council meeting and do it as a citizen. Mr. Moore, as the planning commission representative, you could bring it up at planning commission. You could also go to city council meeting, reference it there, or you could ask me to bring it up to senior staff and ask if there would be interest within senior staff to make a change to the development code.
Another thing that I agree with, and he said it, the people said it, that section of Oxford State Road down there is a unique area.
It is. It truly is.
Well,
Would there be some type of spatial zoning or rezone that up through there to, I mean, it's not gonna help with the shipping containers, but clearly a lot of that's not residential.
Well, there's the thought process of instead of just approving a variety of different use variances within an area that is a mixture between industrial and residential, to do a zone change.
James,
That would be the same process as a text amendment. Text amendment and map amendments are the same process.
the city of Middletown needs to look at that like they never have before. Like they never have before, okay? The codes that we have, we want to honor, that's why this took so long tonight. We want to help the people, that's why it took so long tonight. That is, I just can't think of a more unique place in this city. I can't.
Well, I would want to look at, if we're going to, I mean, obviously, we have an issue here, but I think that there's a difference between saying that this is an R4 question, or whether these storage units for storage purposes, that's one question, at least for me, that's one question. And then whether or not that there needs to be some type of zoning change in the area around Oxford State Road. I mean, certainly we've seen tonight that homes that are now being used for businesses lean more towards commercial uses.
Sure.
So trying to apply code, and, I mean, I understand the predicament there, you know? I think we all do. But there is a big difference between looking at a zoning change for that particular area and then saying, hey, I think storage units are a great use for R4. There's two very different questions there. But I do think Oxford State Road probably needs some work. I mean, you know, I drive it all the time, but I drove it again today to look at these properties. I think all of us aim for fairness, to try to have a good hearing for both sides. But I see the issue there. I mean, certainly many of those properties, most of Oxford State Road, along the frontage of Oxford State Road, certainly leans commercial. And then what could be used there is a question that's open for debate at this point. But again, you know, permit storage versus, as I said, that nuanced argument that we're trying to make, zoning would fix a lot of that. I don't know if it would fix it entirely.
But right now, the way it's worded is you're not allowed to have them commercial or residential, so it wouldn't even matter if it was commercial.
Correct.
Yeah, that ought to be looked at too.
Well,
Chairman, that brings me to the R4 itself. I mean, every time I read it, I think every time I read it, it goes back to referring to virtually, it always says something about downtown. Does it not, in the text?
it does. Well, I think there was a reference on
It
that.
brings you to downtown. And yet it covers the great expanse. all of town.
It's for the core area of the city, and that reflects the historic urban development pattern in and around downtown Middletown.
To me, that's a misnomer.
Well, the first part says core area of the city.
So that's just, and you know, it's easy to pick things apart. My purpose is not to pick it apart, it's just maybe just to really examine things as we go along. It's easier to change these things than to try to change everything every 15 years. If you can do it once a year or once every 2 years or that type of thing,
Well, you know, if you're
I think
looking,
it's more useful.
certainly the code, that's a challenge we run into periodically. You adopt code, things change, and try to make those changes. I think we all know that we had a rough night, guys, I will tell you that. I think it was a pretty rough night for me. But it, you know, again, these storage units, I looked, I looked across cities in preparation for tonight, and the language is very similar in Middletown to the great majority of cities across Ohio, frankly. The code is pretty much consistent with what you would find for these particular units on a permanent basis. There was nothing here that was applied that I think would be much different than what you would find in almost any city our size across the state of Ohio. So whether or not Middletown got it wrong, I think that you'd probably look to other code. In comparison, the code is very consistent across the state. But whether or not this area needs some work in terms of zoning, certainly it does. I believe that it does. But the question again, I feel like a broken record at this point, but whether or not these types of units are permanent uses. You know, you're not going to find that in Ohio, guys. I mean, whether you look at Middletown or you look at 50 cities across Ohio, the code in all those cities that I looked at, it doesn't point in the direction of saying we would like it to be permanent. That's a construction site.
No, the building is all shipping containers.
You're bringing up the point that I feel there's two variables that are being ignored. The size of the storage container varies differently in the application of them. When we revisit that code, we need to make sure those two variables are defined cleanly.
Yeah, you're right. I think you're right.
Because, you know, you're saying you're using them for houses, I've seen that too on TV. And the size of them matters to me. I mean, you can have a storage container that's reasonable, like we've got sheds all over the place. You could call that a storage container if you didn't have a roof on it. So we just have a major topic to address, and I agree with all you guys, presentation and everything. There's work to be done.
And unfortunately, our hands are tied by the code that we currently have, and the code we have to enforce. I mean, I don't agree
Council's
with
the only one can fix that.
the fact that an industrial place cannot have a storage unit, I mean, to have a shipping container technically.
Yeah.
You know, or many commercial applications where a permanent storage, a lot of that's gonna be coming around soon, again, because it's economical and it makes sense. Unfortunately, that's not here right now.
Yeah, renting and leasing property now is through the roof. A small guy cannot sustain his business anymore.
We don't disagree.
No, we agree.
What they want for buildings and stuff, it's insane. It just keeps going on.
So, Mr. Metz, which is the best way to go about this, to get council involved? Should we refer to planning commission first and let them talk about it and make a recommendation to council?
Well, if I may, I like to see staff always alert the city manager.
Well, that's fine too.
Council has its role to play, but you never leave the city manager out.
Well, no.
The city manager has a staff who they have knowledge, quite frankly, the city council does not.
Correct.
Okay, they've got the hands-on.
So, Mr. Gross, to answer your question, a tax amendment would be the best path forward to allow shipping containers within the city of Middletown as permanent storage, as the applicant has stated that they would like, and as the board has mentioned that they would possibly be agreeable to. A tax amendment would be the best path forward. You can, as a private citizen, go to a planning commission meeting or to a city council meeting, and you know, you have your public comment period, time to speak on that. Mr. Moore, as your board planning commission representative, can bring it up to planning commission, and then it can go from planning commission, and planning commission could vote. He could bring it up in new business next meeting. It could be a text amendment that's brought forward. I have to do a legal notice throughout the whole entire city. We have to have 30 days for a public comment period, and Mr. Moore could start the process, if he so chooses, through planning commission. It would have to be approved by both planning commission and city council. Additionally, anybody can go to city council and start the process that way if city council is agreeable. There's also the path forward of going through the staff. If you would like me to bring it up to senior staff, I could bring it up to senior staff. I'm not senior staff. I'm not the one who's going to make the text amendment change. I'm not going to be able to tell you that it's going to get approved. All I can do is at the development committee meeting 2 Wednesdays from now, I can bring it forward. And if staff so chooses, then it'll have to have a legal notice that'll go out to the whole entire city in the Journal News, and then it'll go to Planning Commission and then City Council. And then if it's approved by City Council, it'll be Planning Commission and City Council, and 30 days after that, whatever the text amendment ends up as is what would be permitted. So that is the best path forward to allow temporary storage units or shipping containers as permanent or temporary storage containers for however long that you guys would deem fit, and if that's what City Council chooses. But tonight and before us, what we're dealing with is we're dealing with a code enforcement officer's action of writing a letter that had started for both properties. They wrote a letter determining on the current code, what the code says, and they're interpreting the code, and they're not. That's all they're permitted to do.
Right.
I here am the city's liaison to the Board of Zoning Appeals, and I am only providing you information that the applicant has provided, and I am comparing it to the development code. I'm showing you, here's what the development code says, here's what the applicant is presenting. You as the Board of Zoning Appeals are supposed to use the review criteria located in the development code based off the current text to approve or deny or make a motion to continue for any of these applications. If you guys would like to, allow for permanent accessory structures of shipping containers, which is opposite to the development code, I would recommend going through a text amendment.
I think it probably makes sense to bring this up to senior staff first and just have it discussed at that level, because there's gonna be a significant amount of legwork when it comes to researching what makes sense and a bunch of
Yeah.
variations.
Thank you.
Yes.
Yes, thank you.
So
I'm happy to take your advice.
I think we should start there and we can bring it up, I mean, as soon as the next senior staff meeting, really.
Okay.
And then figure out a path forward and keep you guys updated on where we're at.
Yeah, I'm good with that.
And I think it's agreed that a residential area or zoning should not have a permanent storage unit. But
Right, that's
there are
what I s-
other designations throughout the city, for example, I-2, commercial use, things like that.
Be careful what you wish for.
Right, so.
Does the city allow you to build out of them? Can you build structures out of shipping containers?
That would be a great question for the Chief Building Official, Larry Tuttle. I do not do anything with building permits. I cannot approve.
Like, say, they sell the truss kits where you put the two shipping containers there, and you connect them with trusses with a roof, metal roof over them, and then they offer, is they still consider it a shipping container once you do that?
That's a good question.
Good question.
We've never dealt, I don't, in my 10 years doing this, I've never seen that done. And I've participated on the code before, I didn't see that in the previous code either. It's something that's new that we have to deal with.
But it's coming.
I mean, no matter what, I mean, it's still, they say they're permanent structures, but I mean, you can pick it up, move them at any time. You come in with a truck, move them at any time, so I mean, it's really not permanent. All kinds of variables that go with it, you just gotta figure out.
Yeah, I think if staff is going down this path to review this, certainly I think it's worthy of review, but yeah, I think there was, Mr. Wanamaker raised this question, others I'm sure have as well, about differentiating between these zoning classifications. I mean, what works in R4, what works in industrial.
I've seen a lot of cities, they'll take those and put them together and then put the trusses over it, and then they store their salt and stuff in them.
Sure.
I think the staff and boards and the people have to understand that, it's an imperfect world. You put this stuff in print, it changes tomorrow.
Trust me, I know.
So, staff, when they're dealing with you, their job is to honor this. Okay? I worked in the public sector as well as the private sector. That was my job. Okay? I had to honor the law.
All right.
So staff's then, I guess we all decided, the best idea is let staff study this and get back to us.
That's the recommendation.
Put it in council's hand, for my mind.
Good job.
She has it.
Yeah, that's what she said, though, yeah.
Staff review.
So these other meetings that we can bring us, is the public allowed to go to those and bring stuff up?
Always, always.
When do they have those?
City council meetings are the first and third Tuesday of every month, starting at 5:30 PM here.
Next one you would wanna go to if you wanna bring up something that you'd like to get changed or looked into,
Yes.
to maybe change.
Yep. And then when you come in, there's a public comment card that is basically just it's kind of like a 8x10 or maybe a little bit 4x10 card that you write your name, your address, et cetera, and then what you want to talk about. And then you have 4 minutes to talk about it at the beginning of every city council meeting. 4 minutes doesn't sound like a lot of time, but trust me, it is a long time to get up in front of everybody and speak.
All right, seeing that it's 8 o'clock, we're going to call this meeting, I'm going to call the meeting now. Do we have a motion for adjournment?
So moved.
Is there a second?
Second.
All right, all those in favor say aye.
Aye.
We're adjourned.
Holy cow.
Have a good week, sir. I was like to say, it's Toby Baker pulled the wool over everybody's eyes.
Need to push the stop button over here, or?
If you could, that'd be great.